Hello, everyone, and welcome to today's webinar presentation, What to Expect in 2025, a Highlight Reel. 2020 comes to a close. The 2025 Compliance Strategy Planning season begins, with 2025 already presenting a potential onslaught of employment law updates. It's critical for employers like you to know what to expect in the new year. But before we get further into today's topic, I'd like to take a moment to introduce myself and my organization. My name is Linsky, and I am the Marketing Director of complianceHR. You may recognize my name from the invitation emails that you received for today's event, and some of you may have even emailed me directly about this presentation. But to prevent a few popular questions from entering the Q&A box today, I'd like to let you all know that this presentation will be recorded and it will be emailed to all of you. So please keep an eye on your inbox for an email from complianceHR webinars. Now, a bit about complianceHR for anyone who may be unfamiliar. complianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler. complianceHR is expert employment law guidance in a fraction of the time you would otherwise spend with methods. Our goal is to simplify the complexity of employment law, and we will learn a lot about during today's presentation. To achieve that goal, complianceHR offers a suite of technology solutions around critical HR compliance topics like employee handbooks, employee overtime, independent contractor classification, onboarding, leave, and so many others. Today, however, I would like to briefly introduce you to our two most popular solutions, PolicySmart and the Reference Center. PolicySmart is a comprehensive employee handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and it even sends automated emails to alert you on new legal change going into effect across the U.S. The Reference Center is a solution that combines key employment law and HR compliance topics like final pay, workplace posters, FMLA, minimum wage, and many others. Created to help HR, legal, and compliance professionals do their jobs more efficiently and effectively, this solution leverages data directly sourced from Littler Mendelsohn to ensure answers to your critical questions. If you're interested in learning more, a survey should have just popped up on your screen, though you may have to full screen mode to see it. If you'd like to receive a demonstration of the Navigator Suite tailored to your organization's concerns and risks, simply answer yes, and I can send your contact information to our team of experts. In addition to a demo of our solutions, you may be eligible to receive a limited free trial of our products so you can see precisely how much time and money they can save you. If you're not sure at this time, I'll send the poll out once more at the end, and I'm sure after we've heard all about the handbook and policy updates coming in the new year from our presenters, you may be looking for a way to help streamline your processes around that. Speaking of our presenters, I have the pleasure of announcing today's expert panel, Maureen Lavery, Hannah Stilley, Amy Mendenhall, and Michelle Devlin. The presenters, I'll pass it over to you.
Alrighty, hello everyone. My name is Hannah Stilley, and my colleague Maureen Lavery and I will be discussing trending topics that Littler's legislation tracking team observed during the 2024 legislative year. We predict that these trends will still be relevant looking forward to 2025. I will be discussing legislation regarding child labor, bans on mandatory employer-sponsored meetings, and non-competes. Maureen will be delving into artificial intelligence legislation and how the 2024 election will likely impact lawmaking in 2025. First up, child labor. Throughout 2024, child labor was a hot topic in legislatures across the country. The surge in legislation is likely due to the increase of child labor violations and worker shortages. There were only 3 bills introduced to federal Congress in the last session regarding child labor, and only 1 made it past a committee. Although there was not a lot of legislative action by the federal government, there is further context for the trend. In July 2023, the Department of Labor announced that they would intensify their efforts to combat child labor violations. Please refer to the chart on the right, and you can see that there were increases in cases with child labor violations and penalties from fiscal year 2022 to 2023. However, in fiscal year 2024, the number of cases actually decreased while penalties almost doubled. In November 2023, the Department of Labor's Wage and Hour Division provided that child labor civil money penalty assessments would no longer be on a per-child basis, but assessed per violation, therefore explaining the huge spikes in civil money penalty assessments. In 2024, more than half of the state legislatures introduced bills seeking to either strengthen child labor protections or decrease child labor regulations. In response to the rising violations that were widely reported on in early 2024, many states have sought to increase penalties for violations, create more employer obligations for worker permits, curtail work hours, and we even saw a couple of bills protecting minors regarding terms of compensation. For example, requiring minors to be paid minimum wage in jurisdictions that currently allow employers to pay minors less than the minimum wage rate. Regarding the decreasing child labor regulations, this is likely to help fill the gaps in the workforce. Many states require certain minors to obtain work permits to verify their ages. Several states introduced legislation that would remove the requirement to get a worker permit or decrease the age in which a minor could get a permit. Overall, it would lessen the burden on employers to verify a minor's age. This past year, Alabama enacted Senate Bill 53 that eliminated the eligibility to work requirement for 14 and 15-year-olds. Other legislation sought to repeal meal and rest breaks and decrease restrictions on work schedules and conditions for minors. There were around 75 bills introduced nationwide, and more than 20 were enacted. Here are some notable ones that were observed in 2024. As mentioned earlier, multiple jurisdictions sought to increase penalties for violations, including Alabama, Colorado, North Carolina, and Oregon. We will take a look at Colorado HB 1095, for example. This law goes into effect January 1st, 2025. Previously, an employer guilty of a misdemeanor for child labor violations would be punishable by a fine of not less than $20, but no more than $100 for each offense. This amendment increases the fine to not less than $250, but not more than $1,000. This law also provides heightened penalties for hazardous violations and willful or subsequent violations. In addition, the law also requires an annual inflation adjustment each year. Probably our most unique piece of enacted legislation is regarding a voluntary social compliance audit in California. Effective January 1st, California AB 3234 requires an employer that voluntarily participates in a social compliance audit related to child labor to post a clear and conspicuous link on its website to a report of its compliance with child labor laws. Although there are some parts of the laws that are ambiguous, such as the deadline for posting the report online after the social compliance audit, or how long the report must stay online. It's important to reemphasize that this audit is not required and completely voluntary for employers, but if employers participate, there are multiple disclosure obligations, and you should talk to your knowledgeable counsel about this. Effective January 1st, Illinois will have enhanced protections for minors and increased employer obligations. Illinois SB 3646 limits hours of work and updates a list of jobs that minors cannot hold. The law also modifies the process for obtaining certification for a minor's work permit from the minor's school, requires minors to be supervised by an adult 21 years or older, and requires a meal period. Indiana and Florida removed certain time and hour restrictions. Specifically, Indiana HB 1093, which is effective January 1st, creates multiple exempt categories of employment of minors. And all laws that address time and hour limitations for minors over the age of 16 have been repealed, among other provisions. Lastly, Louisiana HB 156 only requires employers to provide a 30-minute break to minors under the age of 16, where previously state law covered all minors. This topic is here to stay, and employers should expect to see more child labor legislation and regulation in 2025. Our next trend is bans on mandatory employer-sponsored meetings. This topic has been on the horizon for the last few years, and in 2023, New York, Maine, and Minnesota enacted their own bans. On the federal level, there was only one piece of legislation introduced, but the bill never made it out of committee. However, there has been a significant update from the National Labor Relations Board banning mandatory employer-sponsored meetings regarding unionization. However, that is the extent that I am going to discuss the decision, because later in this presentation, my colleague Michelle will be discussing the decision and its impact on employers way more thoroughly. In 2024, 23 bills from 13 jurisdictions were introduced. The proposed legislation typically restricts employers from requiring employees to attend employer-sponsored meetings regarding the employer's opinion on political or religious matters. Some of these bills are being encouraged by unions, as the definition of political matters in some bills include information on unionization and would prevent mandatory employer-sponsored meetings during unionization campaigns. These bills also prohibit employers from taking adverse action against an employee if they refuse to attend the meeting or any other rights under the provisions outlined in the bill. The bills that were enacted and effective in 2024 include Hawaii, Minnesota, Vermont, and Washington. Notably, Hawaii's ban only covers employer-sponsored meetings regarding political matters. Political matters is defined by the new law as anything related to an attempt to influence a future vote by persons in an audience. Laws enacted in 2024 and effective in 2025 include Alaska, California, and Illinois. In the November election, Alaska voters approved a citizen-initiated ballot measure regarding paid sick leave, minimum wage provisions, and the ban on employer-sponsored meetings. This measure will be effective July 1st, 2025. And in Illinois and California, these bans will be effective January 1st, 2025. We foresee that this topic will continue to gain steam in 2025, especially after the recent NLRB decision and the increased legislative activity in 2024. Now we're going to move on to non-competes. The Federal Trade Commission's non-compete rule broadly bans non-competes. However, in August 2024, the rule was enjoined nationwide. Although the FTC is considering an appeal, it is likely that the appeal will be abandoned by the incoming administration. In 2024, there were 35 bills that were introduced in 17 jurisdictions that our team tracked. This included bills that were complete bans or near complete bans with certain exceptions. Illinois introduced a full ban, however, it never made it out of committee. Kentucky, Rhode Island, and Virginia all introduced near complete bans, and Rhode Island made it through the legislative process but was vetoed in the end. Additionally, we observed legislation regarding income thresholds for non-competes, prohibiting non-competes for certain low-wage workers. These were introduced in Connecticut, Missouri, Nebraska, and New York. However, none were successful. Other bills include clarified definitions of non-competes, the legal parameters surrounding non-competes, and industry-specific non-competes such as healthcare. In the end, only Colorado, Minnesota, and Washington enacted laws in 2024. Colorado's enacted law is nothing groundbreaking when it comes to non-competes. Colorado HB 1324 actually modified an exception to Colorado's non-compete law. This exception allows employers to recover training expenses from an employee. This new law allows the Colorado Attorney General to promulgate rules regarding transferability and credentialing available to an employee because of the training. For Minnesota, as part of an omnibus bill, service providers are prohibited from restricting or prohibiting a customer from soliciting or hiring their employees or independent contractors. In addition, service providers are required to provide notice to all employees whose contracts contain an unenforceable provision under the new law. Some highlights from Washington. Washington SB 5935 clarifies the definition of non-competition covenants and prohibits non-compete agreements that allow the application of choice of law of any jurisdiction other than Washington. Currently, 4 states completely ban non-competes: California, Minnesota, Oklahoma, and North Dakota, and over 30 jurisdictions restrict their use in some fashion. Looking forward to 2025, we expect there to be an increase in non-compete legislation as many states were waiting to see how the FTC rule would play out. That is all I have at this time. Thank you all so much. Maureen will be diving right into legislation regarding the use of AI tools in employment decisions.
Thank you, Hannah, and hi, everyone. So, of course, the big AI legislative news from 24 is Colorado's new law. And the reason it's the big news, it's the first comprehensive state-level law that impacts an employer's obligations with respect to use of AI tools in employment decisions. Now, New York City has had a city ordinance regulating AI use by employers in effect since 2021, but that's just at the city level. So this was really the first big state-level law. This law takes effect in February 2026, so employers do have some time to get ready for compliance. The law applies to businesses using high-risk AI systems, which means an AI tool that is a substantial factor in making certain types of decisions, including employment-related decisions such as hiring, firing, and promotion. And there are 4 primary compliance obligations that an employer would have if you're using one of these high-risk AI systems. First is to use reasonable care to avoid algorithmic discrimination, which means use of the tool that results in disparate impact on a protected category such as race or disability. Employers must conduct an impact assessment, which explores the intended use cases, the purpose of the tool, the deployment context, and a benefits analysis of known or reasonably foreseeable risks of algorithmic discrimination. Third, employers must also implement a risk management policy and program. The employer must also provide several categories of notice to consumers, which include whether someone is interacting with an artificial intelligence system, like through a chatbot or through any type of a hiring process that might incorporate some sort of AI. Notice on their website, notice when any data is being collected, and if an employer uses an AI tool that results in an adverse action against, for example, an applicant, the employer must disclose the principal reason for the decision, how the tool contributed, and the right to appeal with human review, if technically feasible. Also under this law, individual consumers have the right to opt out of profiling in furtherance of employment decisions, as well as the right to correct data, the right to appeal an adverse action with human review, if technically feasible. This has been, I know, a really fast and high-level description of what's going on in this Colorado statute. So after the webinar, I'm happy to provide further resources, articles Littler has written analyzing this law, and et cetera. So please just feel free to reach out and I can get those to you. Now, turning to the rest of the country. This is the national landscape for AI laws as it stands today. This year, Illinois also amended its state Illinois Human Rights Act to make it a civil rights violation for an employer to use an AI tool in a way that discriminates against applicants or employees on the basis of a protected class. Utah also enacted a law during 2024, which is not directly employment related, but does require certain businesses that use generative AI to disclose its use if asked or prompted by the consumer who is interacting with the generative AI. The business must also prominently disclose the use of generative AI, for example, on its website. The laws in California and Tennessee that were passed concern the permissible use of a digital replica of a person, and these laws are primarily aimed at the entertainment industry. The New York legislature also has passed a digital replica law this year, and it's currently sitting on the governor's desk waiting to be signed or vetoed. Also this year, California considered a bill that was very similar to the one passed in Colorado. But despite significantly progressing through the state legislature, the bill ultimately failed. The bill's sponsor has already indicated that it will be reintroduced for 2025. However, the version that will be reintroduced will no longer include a private right of action to enforcement, again, similar to Colorado's law. Also in California, 2 state agencies are currently working on draft administrative rules that will impact an employer's obligations related to AI. One is the California Civil Rights Department, and one is the California Privacy Protection Agency. The Civil Rights Department proposal will amend the California Employment and Housing Act regulations and focuses on preventing discrimination in employment due to the use of AI tools in making personnel decisions. And the California Privacy Protection Agency proposal focuses on providing consumers with disclosure and opt-out rights related to a business's use of automated decision-making technology. As for what else we can expect in 2025, we really think that there will be a lot more state-level effort at AI regulation. Several bills have been introduced in Congress, but none of them progressed out of committee. Over a year ago, President Biden issued an executive order addressing AI entitled The Safe, Secure, and Trustworthy Development and Use of Artificial Intelligence. And it gave directives to various federal agencies to come up with guidance to protect consumers related to the use of AI by businesses and employers. However, we expect that the incoming administration will either rescind or otherwise set aside this executive order, which leads to more state-level efforts for regulation. Now, the law that was passed in Colorado was based on model legislation that lawmakers in several states workshopped together with stakeholders, including employers and tech companies. And really, the focus has been on the tension between the desire to protect consumers, however, without stifling innovation by tech companies. This group of stakeholders is called the Multi-State AI Policymaker Working Group, and they work together to develop this model legislation, which we expect to see appear in more bills during 2025. Texas has pre-filed a similar bill, and I believe Connecticut is going to refile its bill from the previous year, and the Connecticut bill was based on that model legislation. Turning to the impact of the 2024 election, I think to lay the groundwork here, I'd like to explain about trifecta states and their impact on passing legislation that's either protective of employers or protective of workers. The trifecta state is a state in which one party has full control. So the state house, both chambers of the state house as well as the governor are all of one party. And as a result of the 2024 elections, Michigan and Minnesota lost Democratic trifecta status, returned to divided governments. No Republican trifecta states changed control. And significantly, both Minnesota and Michigan have enacted significant pro-worker bills in the past few years. For example, Michigan repealed its right to work law, and Minnesota passed a host of employment-related laws, including, and this is not a complete list, paid family and medical leave, paid sick leave, pay transparency, and limitations on non-competition agreements. However, trifecta status does not necessarily determine how successful pro-worker legislation will be. As you can see here, we had Alaska, Missouri, and Nebraska, which traditionally are more conservative states, passed ballot measures establishing paid sick leave in those states. And California voters voted against a measure that would have increased the state minimum wage to $18 an hour this year. There were some hot button issues that may well have driven voter turnout in this year's election. One was reproductive rights, and one is marijuana legalization. I realize many states have already legalized it. However, there are several states where it continues to be against the law. And these initiatives had mixed results, as you can see here. Several states had minimum wage on the ballot, and as you can see in Alaska and Missouri, both states approved minimum wage increases with gradual increases through 2027 and 2026, respectively. Should be said that initiatives that increase the state minimum wage are generally very popular with voters. However, as we just mentioned, California did not pass that measure, which would have increased their state minimum wage gradually over the next few years. In Massachusetts and Minnesota, while these initiatives didn't concern an actual increase to the state minimum wage, they concerned the tip credit for tipped employees, whereby if employees receiving tips, an employer may pay them under the state minimum wage as long as the tips make up the difference. Paid sick leave was also on the ballot in a couple of states. So in Nebraska, Alaska, and Missouri, all three states approved paid sick leave measures, which means employers will need to revise and expand their leave and PTO policies in these states to account for the new paid sick leave requirements. And I'll turn it over now to my colleague, Amy Mendenhall, who would talk about these policy changes and other upcoming changes to handbook policies that are needed as a result of the 2024 legislative year.
Thank you so much, Maureen. Hello, everyone. Yes, at this time of year, I enjoy celebrating handbook season. This is the time when we take stock of what's changed, what changes lie ahead, and what it means for employer policies. So let's jump right in. What I'd like to do is really just kind of set the stage, give you a sense of the kind of volume, scope, and nature of changes in labor and employment laws that impacted employer policies or could impact employer policies this year at a kind of high level without really doing a deep dive on any one particular legal change, but more kind of giving you a sense of the things that you need to be paying attention to as you look at the policies that you put in employee hands. So just to give you a sense of that scope, Stephanie mentioned Policy Smart at the top of the hour, and that's a resource that we work in partnership with complianceHR to develop and maintain, and it includes the Littler-developed handbook policy templates. So looking just at that library of handbook templates can give you kind of a sense of how voluminous the changes are in the area of handbook policy. So just this year, in order to keep that library of templates up to date, we needed to make nearly 50, and I think actually today I will hit the 50 mark by making an update to the comps poster in Colorado at our national handbook template and in the state supplements and supplement for District of Columbia. And you can see just by the numbers here, the states with the most changes this year. Maureen alluded to Minnesota being a heavy hitter, a place where we see a lot of change in labor and employment law in the last year. Also California, probably surprising no one. Connecticut, Illinois, and Oregon were all the states with the most number of changes, and those do really map onto fairly significant changes as well. We did see a couple of laws go away this year. In Euless, Texas, the predictive scheduling ordinance was repealed. New York also established a sunset date for its COVID-19 specific paid sick leave law. So that's one that you can put on the back burner and retire next year. Okay, now looking at January 1, 2025, this slide just gives you a roundup of those changes within 2024 that we're anticipating actually taking effect on New Year's Day for 2025. One to highlight here, and a couple of these we'll talk about in a little bit more detail coming up, but one to highlight is that Colorado comps poster. There's a notice required to be in your handbook. They release a new one every year. Sometimes they keep us on the edge of our seats literally until New Year's Eve of the year waiting for the new poster. This year they got it out nice and early, so do make sure you track that one down for your handbooks. Okay, now looking at all of these changes, we see some kind of repeat players in terms of subject matter areas, certainly paid leave and paid sick leave, and we'll talk about that more in a moment. But we also see some new protections, new leave entitlements, new laws, and often these can be kind of a bellwether for a kind of change that we might see repeated throughout other states. So it's good to keep an eye on them, even if you're not in the jurisdiction that has passed the new kind of protection or entitlement. So starting at the top here, we saw in California, new anti-discrimination protections for quote-unquote intersectionality. And that means a combination of two or more protected categories. Also in California, we have a new indoor heat illness prevention plan requirement. So California already had regulations that required a written outdoor heat illness prevention plan for employers with outdoor workspaces. Now, employers in California need to also adopt a written indoor heat illness prevention plan if indoor temperatures exceed 82 degrees. Similarly, in Maryland, there is a new law requiring employers to develop and implement a written heat-related illness prevention and management plan that's designed to protect employees from heat hazards when the indoor temperature is 80 degrees or higher. So it's not necessarily that this robust heat illness prevention plan would be in your handbook, but it might be referenced in your handbook and it might be included in your kind of policies and procedures. Moving on here to the Crown Act amendments in Colorado to include hair length within, again, those specifically Crown Act protections. Delaware now prohibits discrimination on the basis of housing status. In Illinois, we saw a really significant expansion of the Personnel Records Act, Personnel Records Review Act, rather. So this is the law that governs employees' entitlement to request and review their own personnel records. And they were already very robust in Illinois, but the state made some significant new changes. They set out new requirements related to how employees request these records, including specifying that the request, which always had to be made in writing, can now be made electronically, so including by email or text. They also significantly expanded the definition of what is considered a personnel record. So, for example, that definition now includes things like employment-related contracts or agreements that are legally binding on the employee, as well as employee handbooks and certain written policies and procedures, that the employee may have been asked to acknowledge or to abide by. So that's certainly one to keep an eye on. We also saw in New York a new paid prenatal leave. This is a new law taking effect January 1 that requires employers to provide paid leave for pregnant employees so that they can attend prenatal medical appointments and procedures. Now, just within the last week or two, the New York Department of Labor released some highly anticipated guidance related to this law, which is a novel one and one that might have some employers asking some tough questions and certainly taking a look at their handbooks and policies. Among other things, that guidance did confirm that the 20 hours of required paid prenatal leave are in addition to any paid time off benefits that the employer already provides, whether that's a legally required paid leave entitlement or just something that the employer voluntarily provides. We also saw the advent of workplace violence prevention plan requirements. So first we saw this in California, the first state to have a general industry workplace violence prevention safety requirement. By July 1 of this year, of 2024, employers were required to develop and implement an effective workplace violence prevention plan. So not as a handbook policy, but as a robust policy and plan that could be part of your injury and illness prevention plan, a separate requirement in California, or provided as a separate standalone document. And then following that, we saw a similar new law in New York, which adopted a new workplace violence law specific to retail workers. It requires many retail employers to implement a workplace violence prevention policy, and that one takes effect March 3rd, 2025. And then finally, we saw New York amend its lactation accommodation requirements to require that that break be paid, which is at least among the newer trend. We already see paid lactation requirements in Georgia, Illinois, and Minnesota. I know that Georgia one always comes as a big surprise to employers. Okay, so those are kind of some new laws and potentially new trends we might see emerging in 2025 and beyond. Now, I mentioned that really the subject matter area where we see the most changes this year and for many years now is in the mandatory paid leave landscape. So just to hit the highlights for some of these changes, we could probably spend 1 hour on each of these laws, but just to kind of flag some of the changes you want to make sure you're tackling in your handbooks. First of all, a reminder that we already had some paid family and medical leave laws on the books for which we will begin to see deductions or payroll taxes beginning in 2025. And that's in Delaware, Maine, and Maryland, with then leave entitlements following on that later in 2025 or in 2026 or beyond even. Maureen already mentioned the paid sick leave laws and Nebraska. Connecticut significantly expanded its paid sick leave law, particularly with regard to covered employers. So initially and for a long time, that law has been applicable only to certain service workers. Under these amendments, virtually all private employers in the state will be required to provide employees with paid sick leave. These new requirements are going to be phased in over the next 3 years based upon size of employer. In California, we saw an amendment to the paid sick leave law that expanded covered uses for leave and also makes changes to the unpaid leave for certain victims of violent crimes. Massachusetts, let's move on here to the next slide. Massachusetts expanded its earned sick time law to now allow use of leave for physical and mental health needs of the employee or the employee's spouse for pregnancy loss, failed adoption, surrogacy, or assisted reproduction. So that is a novel kind of protected reason for leave use that we're seeing in Massachusetts. And then also, of course, as Maureen mentioned, we saw significant change in Michigan. The Michigan Supreme Court found unconstitutional some legislative amendments that had significantly revised, among other things, the paid sick leave standards. Once that happened, paid sick leave provisions from a ballot proposal way back in 2018 then became the law effective February 21st of 2025. We expect a lot more developments and change and hopefully clarification with regard to that law. So keep your eye out for news from Littler and from the enforcement agencies as we approach that effective date. So that's the paid leave landscape. I want to just highlight, kind of adjacent to handbook policies, we always keep an eye on what are the required notices and posters. And sometimes those overlap with a written policy provided in the handbook, and sometimes they don't. So we just identify here in this slide, and I won't belabor them here and read them aloud, but just new notice requirements here on the left. On the right, you will find either amendments to the actual notice requirement, so for example, clarifying that it has to be provided in writing, or changes to the notice itself and what's required to appear in the notice. And then finally, just a few kind of process-oriented reminders as we are in the height of handbook updating season here. So number one, as we can see, these changes come at us fast and furious throughout the year. So you're going to want to set up a regular review schedule to ensure that your policies are kept legally compliant. You know, there was a time, I think, when handbooks probably literally in paper could be kept kind of on a shelf without us worrying too much about them for a year or two. But the necessary cadence of our review and updating has really, the pace of that has increased and required a lot more vigilance over the last several years, and certainly 2024 is no different, and 2025 promises more of the same. You're going to want to make sure that you document any changes to your handbooks and maintain copies of prior versions. And finally, you want to evaluate whether things like that notice requirement or other kinds of knock-on effects of policy changes are implicated by your handbook updates or by some of these legal changes. So, for example, your request and other compliance-related forms may need an update. The PWFA in particular is driving a lot of scrutiny and updating to those forms right now. Do you have any posters or notices that need to be updated, either to update the notice itself, or you need to add a new notice or notice mechanism to your onboarding or exit processes or for current employees? And then finally, there may be implications for payroll practices such as your pay stubs related to, for example, new or expanded paid sick leave and paid leave laws. So keep those in mind as you move ahead. You know, one of the big changes we had our eye on in 2024 was the implications of a decision from the NLRB, the Stericycle decision that came down in August of 2023, in which the NLRB adopted a strict new legal standard for evaluating the validity of workplace rules under the National Labor Relations Act. And indeed, that did turn out to be a very significant development that certainly prompted us to review and in some cases update or revise some of our policies or just have new conversations with clients and employers who were updating their policies. So to give us more insight on the implications of that and many other National Labor Relations Board decisions and developments, I'm going to turn this over to my colleague, Michelle Devlin. Michelle?
Hi, everyone. The National Labor Relations Board continued to have a major impact in 2024 and continuing in 2025 on both unionized and I would argue even more so this year on non-unionized workplaces. This slide shows you the current makeup of the National Labor Relations Board. We currently have a D nominee majority, and I emphasize current because just yesterday afternoon, the Senate effectively rejected the reconfirmation of Chairman McFerrin, leaving 2 vacant seats for the incoming president to now fill, and the R nominees to take control of the board in 2025. And I'll talk about a little bit more shortly what that means for NLRB policy. So we had several cases in 2024 with major impacts, like I said, on both unionized and non-unionized employers. In the beginning of the year, you know, when your house is too quiet and it makes you nervous, we were getting nervous. There wasn't that much that came out of the board in the beginning of 2024. In February, we had a decision from a big box retailer which held that the employees wearing Black Lives Matter insignia on their work apron was protected concerted activity, and therefore that major retailer violated the NLRA by instructing its removal. And that was significant because it meant that the sort of spillover of politics into the workplace that we've been seeing lately might be, in some circumstances, protected concerted activity. Then in August, we saw a decision in Metro Health, Inc., which discontinued a practice known as consent orders. This was a tool for case resolution where an administrative law judge could approve a resolution of a case over the objection of the charging party and the general counsel that is no longer available. Then we had this sort of lull, and then, not to be outdone, the NLRB just in the last several weeks overruled over 100 years of board precedent. First, on November 8th, we had in a case Siren Retail overrule a 1985 case called TriCast, which had permitted employers which had upheld the statutory and constitutional right of employers to explain to employees how a union changes the direct relationship that they enjoy with the employer without a union. And I would say if you have any pre-campaign materials or positive employee relations training materials, it would be a good time to take a look at those to see if they need updating as a result of this Siren Retail decision. Then on November 13th, we had a huge decision, Amazon.com, which overruled the 1948 decision in Babcock and Wilcox, which had permitted employers to hold mandatory meetings to share its views on unionization. We're going to talk more about that in a moment. And then just this week, we had a decision, Endurance Environmental Solutions, which in a unionized workplace makes it harder for an employer to defend a unilateral change of working conditions based on a union's having waived that contractually, typically in the collective bargaining agreement. It will now be harder for employers to make that claim. I want to talk more specifically about that Amazon decision about captive audience meetings, because that's really been on employers' minds. So in the Amazon decision, the board held that employer now violates the NLRA if it requires employees to attend a meeting at which the employer is expressing its views on unionization. But the National Labor Relations Board created what's called this safe harbor, where an employer will not be found to have violated the act if reasonably in advance of the meeting, the employer informs employees of three to four things: that it intends to hold a meeting on its views on unionization, that attendance will be voluntary, that employees will not be subject to discipline, discharge, or other adverse consequences for failing to attend the meeting or for leaving the meeting, and that the employer will not keep records of which employees attend, fail to attend, or may leave the meeting. But in the same breath of creating that safe harbor, I ask here, how safe is the safe harbor? Because the board also said that these safe harbor assurances will not protect the employer if, under all the circumstances, that's the totality test that clients love, employees could reasonably conclude that attendance at the meeting really wasn't voluntary, or that they could be subject to some adverse consequence. And so clients are already starting to raise many questions about how safe the safe harbor really is, and other questions about the decision. Now, the answers to all these questions are TBD as cases unfold, but here's our take for now. Well, how much notice is reasonable? This is a question that has come up. We're thinking about 24 hours should be reasonable, possibly the beginning of a shift. Again, this is TBD, but that's our take for now. Well, what about one-on-one encounters? And this decision is about meetings, right? What about one-on-one encounters? Well, the majority board explicitly stated in a footnote 19, that it was declining to address circumstances other than scheduled mandatory meetings with assembled employees. It was not addressing unscheduled one-on-one encounters between agents of the employer and the employee for now. So those are interesting word choices, scheduled and encountered. It sounds like the board wanted to sow some confusion and make it harder for employers to make risk calculations. What about meetings that have more than one purpose? Employee huddles, daily or weekly, are a very common way for leaders to communicate important things with employees about various workplace issues, including about union issues, tacked on to routine topics. So how do we think that a type of assembly will be treated? Well, there's a significant risk that the board majority would find that the Amazon decision applies there. So leaders might handle that by having the routine part of the meeting first, then giving the safe harbor assurance before getting into the part of the meeting about unionization. What if an employee brings up unionization spontaneously, not at the employer's prompting? Well, we think because of that footnote I mentioned and the whole safe harbor concept being focused on planned group meetings, we would argue that the leader is then free in that instance to give their opinion on unionization to the employee who spontaneously asked the question, and that would not violate decision. Again, this is all TBD. And finally, I ask here, do the new rules cover mandatory meetings about other union-related topics like collective bargaining negotiations or strikes? We just don't know yet. We'll see how this plays out. It is possible that the General Counsel might give guidance in a memo before her term is up, like she did with the McLaren-McComb decision. We're not sure if that is going to issue in her remaining tenure. So what are the employer's options when it comes to these meetings about unionization now? Well, the employer can take the safe harbor approach. That is the safest, most least risk-averse approach to the decision. It's really not that onerous to give the safe harbor assurances. And besides, employees, people don't really like to be told what to do anyway. So some employers have found that holding these captive audience meetings, making them mandatory, subject to discipline, really is not an effective approach with their workforce anyway. Employees interested to overturn the decision can file amicus briefs in federal court. They can seek what's called a lead-em action in federal court, which is a type of injunction action based on First Amendment rights. Certainly, employers should conduct or revise their modern labor compliance training to make sure that managers understand the Amazon decision and the others I mentioned. The most risky approach is to bank on the overturning of the decision and continue as business as usual, holding the meetings. Of course, this is the most risky because it's contrary to the Amazon decision that's currently in place. But there are good reasons why we think that the Amazon decision will be overturned by the incoming board or by the federal courts. It's hard to imagine that a federal court wouldn't find this decision to be an unconstitutional content-based restriction on speech, especially given an 11th Circuit's decision in Honey Fund about Florida's law on discrimination. You also have 76 years of unbroken precedent, the lack of deference given to federal agencies since the Loper-Bright decision, and the text and history of the NLRA. All of these are a huge boulder, we think, for the NLRB to overcome in the appeal of this decision. All right, getting into sort of the transition of the board here into 2025, there are several decision issues that were on the General Counsel's agenda that have yet to be fulfilled that are up at the board, but the board has not addressed, such as the employees' use of employer IT systems for protected concerted activity purposes, the duty to bargain over discipline pre-collective bargaining agreement, and the misclassification of employees as independent contractors as an independent unfair labor practice. There are many others. If you subscribe to Law 360, I would suggest checking out their NLRB precedent tracker for more decisions that are teed up before the board. I mean, the current majority still has some time left. We saw major decisions issue in just the last couple of weeks. It's possible some of these could drop before Chairman McFerrin is out. We're not sure. What else do we expect in the administration's transition? Well, certainly the present General Counsel, Jennifer Abruzzo, is going to be fired, just like Peter Robb was fired, and she took his place when the last administration began. Now that we have Chairman McFerrin's seat vacant, our nominees are going to have the opportunity to take the board majority in 2025. There are 2 vacant seats right now. President Trump fills those and fast tracks the confirmation of those. We could see the board majority swing to the R nominees in spring or mid-2025. And with that, we expect to see a change of policies and interpretations on several things that the prior GC had focused and written memos on, like non-competition agreements, electronic monitoring in the workplace, and her really hard-line approach to settlements between charging parties and employers. So we can expect sort of a reversal of or abandonment of those policies and the rescission of her general counsel memos on those topics. My colleague mentioned the Stericycle decision. We can see again sort of an end to the war on handbooks that you saw in the past under the Obama administration and under the present administration. As well, an abandonment of efforts to modify or rescind the 2020 Joint Employer Standard. We expect that the current board will leave intact the 2020 Joint Employer Standard that is more business friendly than had been proposed under the Biden board and shot down by federal courts. And we're also going to see an attempt to reverse the key Biden board decisions on bargaining orders, on handbooks, on confidentiality clauses and settlements. That's the McLaren decision, on independent contractor classification, and on employer free speech. And it could be that federal courts beat the new board to the punch, overturning some of these decisions. So these policies we expect are going to change, and that these major decisions that came out under the Biden board will change. The question really is just the pace. We have just a few minutes left to talk about the SEC and whistleblower protections and employment agreements. I'll sum up by saying that, by way of background, the SEC's role is to enforce securities laws, things like foreign bribery and insider trading and broker misconduct. What does this have to do with employment law? Well, there's an SEC rule which prevents a person from impeding an individual from communicating directly with the SEC or enforcing a confidentiality agreement with respect to such communications with the SEC. This is a whistleblower protection type rule. And the SEC, this is not a new rule, it was adopted in 2011, but this year we saw a batch of enforcement actions came out with penalties that ranged up to $18 million against employers. And these were not just publicly traded companies, they were private companies too. And this impacts various types of employment-related agreements, including employment agreements, confidentiality, releases, non-disparagement, even consulting agreements with independent contractors. Problematic provisions in some prevent employees from communicating, filing charges with, or receiving monetary awards from companies. So I'm going to sum up here because we're running out of time. But the problem is that there are provisions in agreements, in release agreements very commonly, which impede employees from communicating with the SEC or from receiving a monetary award from government agencies, or sort of impeding that communication by making the employee have to disclose to the employer such communications, or only communicate with the agencies involuntarily, such as subject to some kind of a subpoena. The SEC has found that all those types of provisions are problematic. I've given some examples here that you can check out in this PowerPoint going forward. So what you want to do is to revise your offending agreements to take out such communications that prevent an employee from collecting any sort of monetary award from the SEC. And by the way, the NLRB doesn't like these types of clauses either. And include affirmative statements in your agreements that employees are permitted to voluntarily disclose confidential information or otherwise communicate with that government entity, and that the employee does not have to give any sort of notice to or seek approval by the company to communicate with these agencies. If you want your agreements reviewed for such problematic provisions, we're happy to do that, and we also have specific language that we think is effective to include in agreements to prevent these types of SEC violations. And with that, I'll turn it back over to Stephanie.
Maureen, Hannah, Amy, and Michelle, thank you very much for providing us with such great insights for our attendees today. I'd like to offer one more opportunity to sign up for a demo of the complianceHR Navigator Suite. So if you are interested in learning more, our survey should have just popped up on your screen. Once again, you may have to exit full screen mode to see it. As we learned today during the event, policies are rapidly changing from coast to coast. And with the trends 2025 is presenting, It's so important that you do all you can to remain compliant in the new year. Our solutions like the Reference Center and Policy Smart provide you with instant access to updated, legally compliant information and policies directly sourced from Littler Mendelssohn's data and experts. As Amy mentioned earlier, she herself makes tons of updates in our solutions. So if you're interested, then please select yes on our poll, and I will send your information to our team. Otherwise, thank you again to our presenters for such great information, and thank you to our participants for carving out a bit of time during your busiest season. If you have any final questions, please reach out to our presenters. Their contact information is listed on screen. It will also be included in follow-up materials. We hope you enjoyed and have a great rest of your day. Thank you.